Okay, if everybody's ready, we'll go ahead and get started. Hello, my name is Bouvier Yulin, and I am the Director for SCMA. Welcome to Evaluative Mediation Techniques, 7 Essential Questions. This event is in meeting format, which means we can hear and see you. You can hear and see us, so we ask that you stay muted throughout the entire presentation. This event is being recorded. You'll receive a link to all of the workshops for the conference, along with a certificate of attendance for MC3 for all of the workshops, and a certificate of attendance for the workshops that qualify for MCLE in the next 7 to 10 days. If you have any questions regarding the event, or if you have any just questions in general, please feel free to send me a chat. And now I would like to introduce to you our workshop host, Jennifer Johnson-Toronto.
Good morning, everyone. Have you ever been in a mediation where you considered sharing with a party their odds of success at trial? Or perhaps a party asked you the age-old question, what would you do if you were in my shoes? And you almost responded, but then reminded yourself of your neutral role? If you can relate to these scenarios, are interested in evaluative mediation, or perhaps you're wondering if you're already practicing evaluative mediation, you're in the right place. I'm so pleased to introduce you to our highly accomplished speakers, highly accomplished mediators and speakers, Steve Paul and Wendy Kramer, who will present and answer the 7 essential questions of evaluative mediation techniques: whether, when, how, why, who, what, and where. Allow me to introduce Steve Paul, who is a full-time mediator based in Southern California, primarily mediating employment and commercial disputes. He's been an adjunct professor at the Strauss Institute for Dispute Resolution for the past several years, where he teaches employment dispute resolution. He frequently lectures and speaks on mediation, conflict resolution, and negotiation, and is a distinguished fellow and president-elect of the International Academy of Mediators. Prior to becoming a mediator, Steve was in-house legal and business affairs counsel at Warner Brothers Studios, where he handled labor and employment issues and provided legal oversight for the studio's day-to-day operations. Steve is also past chair of SCMA's Employment Institute. He graduated Phi Beta Kappa from UC Berkeley and received his law degree from Berkeley Law School. And now I'll introduce you to Wendy Kramer, who is a highly effective full-time mediator, formerly a partner with Kramer & Kramer, handling a wide variety of insurance-related matters. She's developed particular expertise in matters involving personal injury, business disputes, professional malpractice, real estate, landlord-tenant, and complex commercial litigation. Amongst her numerous accomplishments, she served as the 2013 president of SCMA. She's previously served as SCMA's mentorship program chair, ADR chair for the Santa Monica Bar Association, panel mediator for Los Angeles and Ventura Superior Courts ADR programs, and a fee dispute mediator for Beverly Hills and Santa Monica Bar Associations. She served as on the board of governors for the International Academy of Mediation, where she currently chairs their mentorship program. She's mediated over 3,500 matters and has arbitrated over 300 matters. She's known for her ability to deal with difficult personalities, multi-party matters, and complicated legal issues. I'm sure you're all looking forward to this presentation as much as I am. Just one logistical matter before we begin. Please feel free to ask any questions during the presentation, but please ask all of your questions through the chat function only. Okay, and I'm happy to turn this over to Steve and Wendy. Thank you.
Thank you, Jennifer. Much appreciated. And good morning, everyone. Terrific program. And the genesis for this topic, in addition to over the years, Wendy and I have gone back and forth on evaluation and to what degree we interject ourselves into the process with our own impressions, thoughts, analysis. And there were 2 occasions I had where I had mentees join me and observe mediations over the last few months. And one, smooth sailing, we went through it, got to resolution, and it was a pretty seamless, very positive experience and in process as well as the resolution. The second one, not so much. And when it came time to clearly talk about the various positions of the parties and provide some of my own analysis, then I felt that we were running into a brick wall. It was the magic of mediation was virtually non-existent at that moment. And we got through it after a lot of swimming upstream, which, by the way, I found to be more instructive for a mentee to join on the difficulties of that particular case. But then I began to reflect on, instead of habitually evaluating because we should or otherwise, or it's necessary, it's so nuanced, and there's such a balance and such a timing that I began to explore that and did a boot camp with Stephanie Blondell at Strauss, and then did another webinar. And it's something I'm constantly evaluating on how to be evaluative. So Wendy, I know you have a few intro thoughts, and then we'll dig in.
Yeah, I agree with you. I think that it's something that we do every day, but we wanted, Steve and I, to peel back all the very layers of the evaluative techniques that we all have learned and practiced and used and studied. And when I was reflecting on the topic, I was realizing that probably all of you, I know myself, does this. The minute that I start to convene a case, if it's through my case manager or through a personal contact, I begin evaluating. We're all human, and this is what we do when we're faced with any new situation. We are trying to figure out, in life or in mediation, what are the factors? So I find myself immediately trying to figure out, even before, it could be months before I'm going to hear the case, making some evaluative decisions. Who are the parties? Is it lawyers that I've worked with before? Is it a private law firm? Is it a house counsel firm? Do they have a reputation? Is it a reputation I'm personally familiar with, or a reputation that I've heard about in the legal community? Is it an in pro per? What are the genders and the background culturally of the participants? There are so many things that we start thinking about. Our brains just start percolating before we even get the case in the door. We may not even get that case, but we start thinking about all of those evaluative issues. So I think that, just to sort of preface this whole thing, be mindful of that. And we need to resist making judgments based upon our evaluative, just kind of natures right from the get-go. We have to let curiosity be our guide. And we can then be often surprised at what unfolds as we go through the mediation process itself. So I think, Steve, you're going to start with the whether, why.
Yeah, we're going to combine whether and why as we break this up into whether, why, how, where, who, and what. Let me start off with whether and why, and then Wendy, let me turn it to you. And I want to also just keep in mind, reflecting back to Lee J's, the more that we are interjecting ourselves, our thoughts, our opinions. I agree with what he said earlier, that the least that we speak, the least that we choreograph, orchestrate, the better. I think the more magical a mediation would be organically. That said, I think that there are factors. I am unabashedly, I don't know if I would refer to myself as an evaluative mediator, but as a part of the process, I more often than not am conducting some form of evaluation. I actually want to give you the definition of evaluative in a moment, because it might actually be something different. But also recognizing, as Wendy pointed out, that I do mostly employment, and that is an area, besides being quite familiar with it, but that has lended itself through the market of being an area that it's an expectation that there will be some evaluation during the course of the day. That doesn't necessarily mean that we should do it, but we'll get to the why in a second. And then, you have to understand, are the parties represented? I only work with represented parties by counsel. If not, I would take an entirely different approach on evaluation? What are the market expectations? What jurisdiction are you in? Who are you working with? What are the cultural norms? All factors. Let me just provide the definition of evaluation, and which is an assessment or to form the idea of a value to something, to provide an appraisal. I don't think that I do that. I don't think I go that far. That is, we've come to use the term evaluation, but I don't think it's in its Webster's dictionary form. I think, at least for me, it's more providing my impressions, my thoughts. And as we go through our session, we'll dig into that a bit deeper. Why? Often because I think that it is a necessary component to work through the day and get to a resolution, because it's rare that both parties have a similar valuation or similar in their positions, or they don't have their own biases or confirmation biases or confidence biases or perspectives. I think, Jennifer, as you point out in the introduction, we want to put ourselves in the other's shoes, but when you're only wearing your own, it may require some form of evaluation. Rarely do you hear, but once in a while, Steve, listen, we've got big problems. We know what they are. Let's just get through the day. And so those are my initial thoughts on the whether and why. Wendy?
I would say that in reflecting on this part of our talk, Steve, and I shared this with you, I really don't like being put into that role of being evaluative. However, as much as I try and resist it, and my book of business is mostly personal injury, but sprinkling of all of the other things that Jennifer mentioned in terms of business disputes and landlord-tenant and whatnot. And I would say that in Southern California, the market demands it. In the litigated case, it's just simply a part of what everybody feels they're paying you all of these mediation bucks for. And that's just the practical aspect of it. And one of my best friends is a lawyer turned insurance professional. She decided she didn't want to practice law any longer, and she works for a national insurance company. And I've had many conversations with her about effective mediators and not effective ones, and what she likes and what she doesn't like. And one of the things that fits into this part of the topic is that she says insurance companies want a neutral's opinion. That's what they feel that they're paying for. They want that evaluation. They want that other third-party look on what they've done already to build up to that mediation day. And so when neutrals resist it and aren't willing to give it and whatnot, she's left frustrated, and her colleagues are left frustrated that they haven't gotten full value for their mediation buck, so to speak. And more on this later, but the things that we're evaluating, of course, are, in the litigated case anyway, evidence, facts, including witnesses and the legal arguments that are being made. But we'll delve deeper into that in the what section. But I think generally the whether and the why is unfortunately being driven by my clients and perhaps yours as well.
Yeah, and by the way, to that point, as to the why, I very much agree with you that often, we see what's before us, whether it's virtual or in person. That's for a different day. And there are various layers behind each of the participants that are there and that aren't there. And so to that degree, we have to be mindful. And sometimes we are looking to provide cover, or there are dynamics at play where we can actually assist them if the client feels that, or the counsel feels that the client doesn't have a realistic assessment of what would be a proper settlement, or a carrier needs to go back and take a mediator's proposal. So I agree with you, Wendy, and I'd like to, since we've kind of going through this whether and why, there is, Phyllis, I want to just take a moment by evaluating, are you not being partial and biased? And I think that I didn't want to ignore that at this stage, and Wendy maybe have some thoughts, is when we get to the how. I'd like to talk about how I attempt to minimize that risk. Because I think that your point is and getting back to what Jennifer said in the introduction, we have to be reminded ourselves of our neutral role. And there's some questions and some avenues that I would be more comfortable than others to weigh in on.
All right, so I'm supposed to now segue into the when of this. And I will say that I don't know if it's because of the virtual platform of Zoom, but I've found it increasing pressure early on in the mediation in my cases to do it. So I can get somebody saying, "Good morning, Wendy, it's nice to see you. By the way, we're going to need a mediator's proposal in order to solve this." And I tell you, it happens regularly. And in the first 5 minutes of a mediation, I say, seriously, folks, you know, I try to deflect that. I don't want to be in a position that I know I'm going to have to be evaluative and give a mediator's proposal. So I try to empower the participants by saying things like, you know, look, if we have to, we'll get there, but let's go through this process. Let's go through the day. Let's do all of the pieces of this and try to get you to come up with your own solution rather than interjecting me. I'm just one other person. So my role here today is more as a coach. I'm trying to be neutral. I don't want to just tee this up for a mediator's proposal. That seems to me to be shirking my duties. If we're going to do it that way, then you should have just sent me briefs. I would give you an opinion on paper as to what I think the value and who's going to win on this point or that point, and we'll call it a day. But that's not what mediation is. So I try to, like I said, deflect them and go through the full process. That being said, most of my cases are only 4 hours. And when Steve and I were planning this, he mentioned that that's significant because most of his cases last an entire day and sometimes go on into the evening. I can count on, you know, maybe 30 cases in my whole career that have gone on that long. And I do 4, 5, 6 cases a week. So the bulk of my business is 4-hour time slots. So I have to be very mindful of time. So yes, I don't want to be evaluative, but at some point, if we're 2 hours in and we're still talking about arguments and facts and legal this and that, then I have to try to move people away from that and into the negotiation frame of mind so that we can potentially get a resolution. So in doing that, I do find myself evaluating the relative strengths and weaknesses of the positions that are being taken. And but again, I'm trying not to impose my view on any particular person. I'm just asking questions, expressing curiosity. Have you thought of this? You know, those sorts of things to bring them to their own conclusions and their own evaluations, and maybe question the way they came in that morning for evaluating and come up with a different conclusion so that we can move it along. And the time constraint, lastly, it actually sometimes works to my benefit. Because I do have to move it along, and we can't, I think negotiations expand into as much time as you give them generally. And they'll tell you that. They'll say, well, we booked you for a full day and it's only 4 o'clock. So we had you till 6, you know, and they'll just keep you going. So with a 4-hour time slot, and I know I have another case to start in, you know, a half hour after them, I'll tell them, you know, I need to eat. So let's get going. And that helps to move it along.
Yeah, no, that's so interesting because I do some half-day cases, and I find it to be with similarities, in not trying to cut corners or allow parties to breathe, right? I mean, to breathe the human element, whether it's employment or virtually any dispute, it is a human element of fear and anxiety, betrayal, loss of self-esteem, loss of income, worse. And we have to continue to be mindful of that, and especially when we talk about the concept of evaluation, the brain versus the heart. And so in terms of the when, is, I would say, generally speaking, I really don't want, sometimes you get asked at the beginning, top of the hour, what do you think of my case? Well, I'm I'm not going to thank you for that question and your trust. I'm not just going to entirely ignore that, but I think at this point I'd rather hear from you. You know, what's going on? Tell me about what you'd like to emphasize from your well-written briefs and what you provided me. We could talk about that later, but I also want to give the counsel the opportunity in front of their client to go ahead and present, and if they need to do some advocating, right? And although the other day, I have to admit, there was right off the bat, lawyer I worked with several times said, you know what, this is a nonprofit and the nonprofit's never going to be ruled against by the jury. I was thinking to myself, okay, do I let that go? Do I say something? You know, it's kind of like, you know, the devil and the angel. And I said something very politely, but usually I will wait. And preferably it's, Steve, tell me your thoughts, or, you know, what are you hearing in the other room? And I really would much rather have that invitation than to go ahead and go on my own. You know, and Wendy, between, you know, Lee and Floyd and Phyllis, I mean, there's so much here that we could dig right into, and on it goes. So, and I think to Floyd's, you know, are we challenging, asking questions and challenging? And I don't know that I was use the word challenge, because that can be positional. I would use the word offering our own impressions, and trying to conduct myself accordingly. So anything more on that, Wendy, on the timing of when? And then I think the meat is in the how, but let me turn it back to you.
No, I think that that's all I had to say about the timing. And I think that you started to delve into the how. So I think you just go right there.
Okay, will do. Again, I'm going to talk about what's been spoken about earlier today, is still to offer that safe space. And the how, I'm just going to throw out what I remind myself. Each time I start, I carry a little crib sheet, you know, that every morning I look at again, because I want to make sure they're fresh in mind. If so, it's with humility, it's with care, it's with authenticity, it's non-judgmental, right? So those are the broad principles of how. What I would typically do is say, you know, look, I've represented plaintiffs, I've represented employers, I worked in-house at Warner Brothers, I've been a mediator, primarily employment for 15 plus years, done, you know, a number of cases, but I haven't done yours. I have not worked with your case, and I will not know it as well as you will. And I am not going to predict your outcome or put a value on your case. Yet I can offer my impressions and thoughts, whether it's on exhibits or whether it's on the law, but that's all that they are. And please be mindful of that. And sometimes, as if I was a juror, what would perhaps strike me, I am not, or your judge or arbitrator. And I would also not just talk about the, you know, weaknesses or the challenges in a particular case, but the strengths, because I think that's really important to our authenticity. Otherwise, it appears that we're just going in and saying, you know, here's why you need to come way up. It's because this, and this. Well, I don't think that, for me, that is a preferred approach. And I like just to see myself as a resource. And like I said, well, and has been said, is asking questions and not charge questions. You know, how do you see X as a witness? How do they do in their deposition? How do you feel about being in arbitration? How do you arrive at your valuation? Okay, and often towards the end of the day, do some kind of a decision analysis. But we have to be mindful of who we're talking to. Let me pause there. Wendy?
I was reflecting on something that Lee J said last night in accepting the Peacemaker of the Year award. And he's with us in this workshop as well. And he said, and I quote you, Lee J, "I have no problem telling people what they should do." And I think that's really interesting. I don't either, and yet I find myself trying not to, you know? I had a mediation last week in which I was trying to create a joint session and bring everybody together. And interestingly, in setting at the stage to make that happen, one of the attorneys who I'd never worked with before said, "Well, but I've heard that you don't like conflict, you don't like arguing." And I said, "I don't know who you heard that from." And that was that particular case, similar to what Steve's saying, you know, we're dealing with the case that's in front of you. And it's true, I don't like disrespectful language, but it's, you know, it's my diagnosis right now and my opinion that coming together, and if there's loud words and there's emotions expressed, it's going to be useful for us. And so that's why I'm encouraging it. And I can deal with it. I trust you. I mean, trust me, I've done it before. So in that way, I do tell people what I think they should do. They don't always listen, of course. And as Steve said, you have to be very careful in choosing your words and not be, you know, bossy. But in some rooms, I need to be very clinical and businesslike, you know, in the insurance room and take the emotion out of it. And in the other room, I need to be very mindful of the emotions that are being expressed. I had a woman the other day tell me very heatedly, and she's very well educated CEO, that the fingering injury that she had felt like a rubber band was tied around her finger, and that neither I nor the other insurance people understood how this affected her every moment of her working life as she tried to type, at home as she tried to braid her 5-year-old's hair. You know, these are the kinds of things in terms of how I have to convey that to the other room, but not in such an emotional way that I'm going to turn them off. I have to find the right words so that they understand that that has value economically in terms of pain and suffering damages. So I think that one tip I would give to all of us on this call is to take a break in between rooms. If you're doing Zoom mediations, which I'm still doing primarily, click yourself back into the waiting room, take a breath, walk down the hall, do whatever, and then get your mind in the fact that you're going into another room, just like you did when you were doing live and in-person mediations. Don't just go from room to room. When you do that, automatically, I don't think you're able to do the how properly and really choose your words and be mindful and respectful in how you're perhaps being evaluative, but not being so bossy about it.
You know, that's so interesting you should say that, because sometimes I think it's a great reminder, Wendy, because I'll feel that, you know, more than in person, that, well, they're sitting in front of the screen, they're waiting, let me just jump back in without taking that pause. And I think that's a very good tip to be able to do so. One thing I love about our mediation practices is that we work through the day. We don't know what to expect. There's going to be, you know, curveballs and different dynamics, and we just go for the most part. But yet, in doing so, we do need to pause and stop. You know, in my own practice, I was probably overly analytical and, you know, analysis by paralysis, and you just don't have that luxury when you're mediating during the course of a day. But I think that is really a very good reminder. Let me ask you a question, Wendy. Is what do you do when you are being provided with, let's say, the law that is just, you know, not at all accurate? How do you handle that? And you've heard it now 2, 3, 4 times in your practice. What do you do?
Well, one technique I will do is sometimes it's the insurance person that's spouting off the law, or the actual plaintiff, and so they're not the trained person that went to law school, or the person that has to present the case in front of a jury or a trial judge. And so I might redirect the question to the actual attorney, usually it's the insurance room, and say, I'm curious, Ms. So-and-so or whatever their name is, how do you feel about presenting that argument in court? What do you think your chances are? And they are usually willing to be very candid and say, I can't go there. That's not going to get me much traction, or that piece of evidence is likely going to be not admitted, and yada, yada, yada. And so again, I like to empower the people themselves, the participants, to reach their own evaluation on the legal argument that's being propounded. But a lot of specious legal arguments are being made, and sometimes, going back to what you said in terms of emphasizing your experience and background, if I have to, I'll pull that out of the pocket and say, look, I was a litigator for 20 years. And if I were your lawyer, I would not think that would be a good argument to make, or, for whatever reason, bringing out your background and your experience.
And of course, you need to be mindful because of the attorney-client relationship, the carrier attorney-client relationship, the decision maker, the CEO, and all the way down the line. All the more reason to be really mindful of the balance between moving this forward to a resolution, and what I like to think about is what happens after they're no longer in front of us, even with a resolution. Will there's still relationships that they have that they carry, and I want to be really careful about that as well. So we've talked some about the how, the when, the whether and why. How about the what? What is it, Wendy, that you will weigh in on? What areas?
I mean, typically it is the evidence, the facts, it's witnesses. For me, it's very heavy on witnesses and giving my opinion on whether I thought that somebody makes a good presentation to me on the Zoom platform or in person. But I will always start with asking the attorney, look, you took the deposition of so-and-so, you spent 3 hours with them. So what was your impression? But then I'll be honest about whether I agree or disagree. And I'll temper it with the fact that, of course, in front of a mediator, they're not being cross-examined. It's a very friendly environment. And so I'm getting their best foot forward typically, unless they're a high conflict personality, in which case I'm always getting their worst foot forward. But yeah, I think that it's mostly I'm willing to give my opinions about credibility of witnesses, a story that's being told, whether it has holes in it. I like to make everybody show me the money. So you said that you made a representation that at the deposition, so-and-so said such and such. Can you please send me that page and that line? Because when you read it, it turns out maybe it doesn't. As you're testing the credibility of what's being told to you as a fact, it turns out it's not a fact. Medical records, same thing. If I get them to pull up the medical records, and this was so much easier in person, and we could look at them and read them rather than do this share screen and find them on computers and whatnot, force them to take a look at them, police reports, any kind of photographs, any evidence that they have. They'll show me, one person will show me a photograph of a damaged vehicle and they'll say, there's no damage here. And the other one will say, yeah, but look at the property damage estimate. The frame was broken and we have the black box and it shows that the car was going X amount of miles per hour at the time of the collision. And it's much more significant than what they're trying to paint it out to be. So it's really testing the evidence and the facts for me. And the story itself, are there holes in it? Does it make sense? Somebody will be complaining about one aspect of the story, and if I can find out what the missing pieces of the story is and pull it all together, then there'll be an aha moment where they say, oh, okay, now I know why that happened, and so I'm going to back down a little. And the other thing is the value of the case. Again, increasingly in my practice, people are wanting to know, how much is this case worth? And again, I try to redirect it and ask them, well, you've roundtabled this case in the insurance room, they've done that, and you've talked to people, and what is it that you've used to reach your evaluation? What factors? Are they verdict reports, settlement reports? Have you done a mock jury? Do you have claims, settlement statistics, those sorts of things? And lastly, I keep notes. If I have a case that hasn't settled, or there's some big case in the news that has to do with my practice, I'll write a little note about what the verdict was and how it was decided, and I'll bring that factual aspect into it to try to get some color there and some background for how they reached their evaluation.
Yeah, by the way, I find these conversations to be fascinating because we all have our different styles and approaches, and they're evolving, right? I wouldn't say that I'm habitually an evaluative mediator and this is how I do it, or this is once we've discussed the merits and potential damages, we are done, and now we pivot to negotiation only. I don't think it's that clean. And others might take a different approach. But as I sit here, Wendy, and we talk about the what, right, of what is it that we're providing our input on, I would agree. Facts, exhibits, potentially contract language. Often in employment, the issue presented is whether or not comments or behavior is considered severe or pervasive to reach a hostile work environment or actionable discrimination. And that is an area that I find with the defense that often, well, this is innocuous and it wasn't severe or pervasive, or they'll say severe and pervasive. And I will say, well, it's severe or pervasive, and oh yeah. And then we go from there. And again, I'm not going to say, no, that is severe, that is pervasive. But, if I was a juror and I was sitting here and in the context discussed, I do think that could be troubling to me. I don't know how it presented in court. There's all kinds of other dynamics. And that's how I might weigh in on that. And so the other elements of what else we might opine on are coaching the negotiation to some degree. And what are you trying to accomplish by that move? What do you hope to achieve by that move? What do you think? How do you think they will react to that move? Interests. When a party says, you know what, I will take this all the way to trial. I just don't want this to happen again to anyone else. We don't want to establish precedent. I want to teach them a lesson. And those are things that I will take a pause in and explore. I wouldn't say evaluate, but further explore those interests because those are highly personal interests. And I'll tell you what I won't provide input on is what is my case worth? I also tend to not weigh in on who's telling the truth and who isn't, because I think that gets into a bit of a battle over veracity, and I think it could be highly polarizing. What would you do if you were in my shoes, right? As Jennifer mentioned in the intro. I suppose, and it's usually later in the day, I'd say, look, I'm a mediator for a reason because I think resolution is priceless. So that's my starting point. What you do is something that requires further reflection. I'm so glad that we're having this opportunity today. And what else do you need? Because I think there's also a tension, last thing I'll say here, is between getting a resolution done today, as we are tasked to do, versus just having the parties make an informed decision on their own decision on and empowering them to make a wise choice for them. And I think there's been discussion on other listservs about what is a successful mediation. And I think it's the latter, is to allow the parties to be further empowered to make a decision. Okay, let me stop there.
I agree. I don't think a successful mediation is one that always results in settlement. I have many mediations where we don't settle and people are very kind and grateful and thankful that we had the session, and they feel that they've had, things illuminated for them, and then we're going to go on and we'll continue working on it in the future. But a settlement where everybody's unhappy, I don't find that to be very satisfying at all, even though it's resolved and it's a closed case. Those are my least favorite settlements. I wanted to address the where just briefly. I know we're running out of time, and I think that the cardinal rule is where to be evaluative is never in a joint session, just always in caucus, and often with just taking the attorneys aside away from the client and asking them and doing it very carefully. Again, I don't think mediating dangerously applies in this situation. If you're forced to be evaluative, you have to evaluate carefully. You cannot override the legal opinions and the advice of counsel that they've spent years formulating, or the emotions of the parties or their family members or anyone at the table. And I think you have to continue to ask questions at every step of everyone who is present. Is that okay with you? What are your thoughts going forward? How do you wish to handle this, so that it's a full, robust situation where everybody's making the decisions. You are not just enforcing your opinion on other people.
Yeah, no doubt. And on the where too, it is, I don't like having extensive conversation just with counsel without the parties there. From time to time, there is a benefit of Zoom that, you pick up the phone now and again, or you send a text now and again, because the where isn't to challenge the attorneys in front of their client directly and being evaluative. And I guess that's all I really have to offer on that. And then there's the who, right? Who are we? Who's our audience when we are providing insights or our own thoughts on a dispute? There's the clients, there's counsel, there's a carrier, there's potentially a board of directors, there's a spouse, and there's no one size fits all at all. Is that I will most often, when there's a board involved, ask if there is someone, instead of having information filtered through the day, please sign on, join in, let's invite that individual, because they're also going to be accountable when they report back on a decision, and I would like them there to be able to participate. And I think we need to, on the who, be mindful of who've been the decision makers and who are the drafters. If we're looking at an employment contract, for example, and I'll ask the question, hey, by the way, Wendy, did you have a hand in drafting this? No, that was, so not that you want to throw someone else under the bus, but I don't want to throw you under the bus. And I know that's a strong, just using that for emphasis, but I think we need to be mindful again of post-mediation. And when we're doing our thing and maybe a case resolves, what's going to be the impact on that human resources professional, on a supervisor, and again, all the more reason to not exert judgment. We do have, and let me go back to Wendy in a moment, but there's some very interesting comments in the chat room. Do you want to go ahead, Wendy, and start off, or?
No, I think, do you have a specific comment that you wanted to highlight? I'm just scrolling through them now. There's so many of them.
Yeah,
because we're kind of we're running out of time. We have like one more minute.
Do we? Is that right? Or do we have 12:15 or 12?
No, you have until 12:15.
Oh, 12:15. I'm sorry. I thought
time?
that we had an hour. Okay,
We
cool.
got boatloads of time.
Oh, yay. Then we
by
can
the
have
way,
a discussion.
I see my mentee Alexis is in with us, and she was a part of a thorny mediation quite recently. In fact, to your point, Wendy, about knowing who your counsel are that you've worked with, and do you have preconceptions about how the day might go? I invited Alexis because, I think was important to see in this, highly, aggressive employment field in Southern California, tough days. But, I want to go back to Phyllis. You said, and I know you teach ethics at SC, about the ethics in the minefield involved of when an attorney is wrong, right? And we could discuss that, for hours. Again, I think we need to be aware of it. And there's a difference between educating counsel in one room to help them with their case, or evening the playing field, shall we say, versus just, talking about, let's say, the standard of severe or pervasive, and it's different than severe and pervasive, and just saying, let's talk about that. Where do you get kind of your support for that? And I just want to highlight that, because we do need to tread mindfully and not overstep our boundaries. On mediator proposals, I make it quite clear, a lot of jurisdictions will not make them, period, because of the fear of us overexerting our influence on outcome. And I will make it quite clear, this is not who do I like better, how I value a case. It's what do I think would lead the highest likelihood of a resolution.
I think Floyd made a comment in the chat section about that as well. And that's entirely, I have to make sure my parties understand that when I'm making a proposal, I am 99% of the time not being evaluative. If they ask me to be evaluative, then that means I have to write like an opinion letter, sort of like I did when I was a defense counsel, evaluating every aspect of the case and the facts and the legal positions and who's likely to prevail on this and that and the other. And that's not my role as a neutral. So my role, along the lines of what Floyd put in the chat, is just to try to determine as best I can after 4 hours or after 7 hours, what's the highest amount of money that the insurance company is going to be able to get permission to pay on a mediator's proposal, and what's the lowest amount of money that the plaintiff is going to agree to sign a release document to settle his or her case. And so it's not evaluative. It's after all of this bargaining has taken place that we do that. I was just reading what Dr. Jack Getz wrote from a theory standpoint. He's saying most mediations need an evaluative phase to settle, and I 100% agree with that. And that doesn't mean that the mediator has to be the one evaluating, but instead providing information and asking all the probing questions that allow the parties to evaluate their own positions. And I think that's brilliant. That's exactly what most of the time needs to take place. But again, unfortunately, in this market, in this legal climate, sometimes they want more, they want that. They want you, I would be asked specifically, Wendy, I want you to pretend you're the 13th juror. What would you award? And I find that very uncomfortable. I really don't enjoy being in that position. So I will preface it with telling them that I'm really uncomfortable about that. Because not that many cases go to trial any longer. And so you don't have that. I had a case the other day where they were looking at jury verdicts to try to establish value, and the jury verdicts were 20 years old. They couldn't find anything more recent about this particular type of injury. And so, then they're arguing inflation and the cost of living increases and this and that. And it's like, oh, come on, people, this isn't working. So it's very difficult to be some sort of factually evaluative person in this particular market when very few cases go to trial. Most cases are settled, and each case settles. You could take the same facts of any one of my PI cases and you could put them in 5 different insurance companies throughout the Southern California area, and you are going to get wildly different evaluations from each of those insurance companies. And so I say that to try to deflect it. This is an example. My insurance friend that I told you about, they just did a focus group, mock jury or whatever you want to call it, on a case. And they did 2 different focus groups. And one of them came up with a verdict. They knew it's a liability case. So it's just a question of damages. One of them came up with a $2.5 million verdict. The other one, $18 million. So a fat lot of good that did them.
Exactly. You know, it is so interesting. And I do think that asking questions, I mean, we've all heard this over and over, but it does bear repeating because, you know, they're coming to us because they, I think as Harold mentioned, they've already reached impasse in a sense. Well, and there's also another factor, and I do think for another time, is that it would be nice if attorneys could talk to each other more often and not positionally. And I do encourage that. I've just started more of, because it's easy on Zoom just to say, okay, I'm with you guys, go in your breakout room. You guys go in your breakout room. It's like, no. Let's say a quick, you know, I've talked about the case, but can we just, let's say good morning, you know, maybe without the parties. Parties may be in distress. If it's a sexual harassment case, especially, or an employer that feels that they're being, you know, extorted, you know, do no harm, you know, out of the gate. And not that you do harm later, but you know, I think we are about, you know, presenting options through the day. And I would love to have counsel be able to spend more time discussing the case together. And I guess 2 quick points. The other day I asked, you know, so, you know, Tim, have you spoken to opposing counsel about the case? What got you here, right? Bunches of information to get out of that. Yes, here's all the emails that we've sent to each other about our respective positions. And we had a 2-hour frustrating conversation. Helpful information for me to know kind of how to navigate the day. And often it's, look, I'm not here to convince you or otherwise about your position. You have every right to go ahead and continue further or file motions or take depositions. Ask yourself, though, will you still be in the same place, perhaps with making it harder to resolve later? So let's talk about these, you know, these things. And then again, lastly, I'll say is on the interests. Maybe a company is on the verge of being sold and you need to clear a case off their books. Maybe an employee is moving back to Iowa imminently or starting a new job. And that will affect their valuation that I may not even know. So I cannot and pretty much will not tell them what they should settle their case for or not. Give my blessing. Thoughts on that, Wendy?
I agree. I found out after the fact some astonishing reasons why, you know, cases settled for more or less than I thought they might throughout the process. You know, you do form, you might not share your evaluation, but in you know, your mind is cooking and you have an idea sometimes pretty early on where you think the case will settle at or within a range. And then if it completely blows that statistical average out of the water, you've come to find out that, you know, somebody was facing an IRS, you know, issue, or they were about to go to jail, or they're leaving the state, or they're not even. So in Zoom, interestingly, you know, trial is set for December 17th. Well, it turns out that the person that is going to have to appear for trial is now living in Venezuela, you know, and is zooming in from Venezuela. And the defense doesn't necessarily know that, and nor are you permitted to share that. Because then that drives the value down, because they know that person's not going to probably even be let out of Venezuela because of COVID to come to their trial in Los Angeles County. So there's all sorts of variables that feed in, and I think Jan Shaw put that in the chat as well. There are so many different variables that feed into what a case settles for. The negotiation skill set of the parties, you know, you see it on your watch where people leave money on the table, or maybe somebody overpays because of the skill of the other party and continuing to just not back down, and they finally cave in. When you know, because you've worked with that person before, that they're just, you know, trying to steamroll the process, but the case settles anyway. So it's fascinating, all of the different factors. I love my job.
I love my job most days. And Wendy, it's interesting that you say overpaying or settles for less than value. I mean, in and of itself. And I do think our practice
Yeah.
areas are very different. And,
Yeah.
and it may be easier to quantify evaluation in yours versus what would emotional distress award be.
Right.
And liability, I think you said, is contested in maybe half your cases, but not the other half. And I would say, except for some wage and hour cases where it's just statutory. In the cases, liability is hotly contested. But I just found it interesting just to comment that, do you at times, not that it matters to you, as Floyd put in the chat room, one way or the other. I'll sometimes say that, by the way, with all due respect, whether your case settles for 50,000 or 250 or anything in between, it is of no moment to me other than, is it something that when you put this case aside and you reflect on it, that it is satisfactory to you, period. Should we have a few minutes for comments or questions? I think we have just a couple. What do you think, Wendy? Or
Sure. Yeah.
should we open it up? Maybe throw something else in the chat room, or we could even be bold and just take, anyone want to add anything? We just put it right out there.
Lee J is chuckling.
Is he?
He is. He's chuckling mightily by being bold and opening it up.
Well,
Anybody have anything that they want to comment upon? You can raise your hand. Jan Shaw.
Unmute. I'm always curious whether when you're asked to evaluate, you evaluate honestly, or you evaluate to a place that you have some intelligence that suggests that that's a place you can get in terms of a settlement. When somebody says, is my case worth 100,000, and that the other side has 100,000, do you say yes? Or do you, try to, get that 20,000 off or something? Just curious how you play that out, and, what the ethics or even the sort of personal reaction or response is.
Wendy?
Steve, do you want to tackle that, or you want me to?
You go first. It's intriguing. It's a good question.
I think my response, Jan, to that question, and it's a great question, is usually to say perhaps. Because again, it's worth 100,000 if the other side is willing to pay it, right? But I don't want to, even if I know it's been told to me in confidence. I do have a few clients that'll come in and I don't really even enjoy this, and they'll say, Wendy, we have X amount of money, you do what you want with it and you settle this case. And so then I'm put in this really awkward position of being the only person negotiating. So I don't like that. And then the situation, the hypothetical you're posing, is I've been told at some point during the mediation that they will pay up to 100. But you know what? People lie to the mediator constantly, and that's not necessarily a true statement. Maybe they'll pay more, right? And when people give you, for example, brackets, sometimes they don't even intend to get to the midpoint of the bracket. So people fudge around with that as well. So I say perhaps, and then go on to the next question. Lee J, did you have something you wanted to say?
Well, let me just real quick, and then Lee J, go ahead. Yeah, I just, I really, when I see that, Jan, I will bend over backwards to not interject myself into those numbers. And when I see an overlap, and if it's a proposal, I'm not going to favor one side or the other at all. And the last thing I'll say about it's different topic brackets is I just like to confirm what their intention is in providing a bracket so there's no confusion. Lee J.
I just think we've got to be really careful to be clear about what we're offering. If they ask us for an evaluation and we give them something other than that, that concerns me. I think all that we have is our reputation and their belief in us. I had a dear friend and colleague who used to do mediators proposals in multi-million dollar cases. And he would tell one side the proposal is 40 million, and he would tell the other side the proposal is 50 million. And the plaintiff would say, that's too low. And the defendant would say, that's too high. And he'd say, how about I make another one? And he'd make a second one. But by the way, he never told them that they got different numbers. And then he'd make a second one at 45, and they both say, that's better. And I just thought to myself, how long before the day comes when they ride the same elevator down and have a conversation? And what happens to his reputation and his career? So to me, if I'm making an evaluation of my opinion of value, which is a thing I do so rarely, I make sure that's what it is. And when I make a mediator's proposal that's not that, I make sure they understand this is not my opinion of value. This is a place where I think if you both stretch to a point and then a little bit more, you might both get to the same number. But I think we have to be clear in narrating what we're giving them and not risk the things we say get misinterpreted all the time anyway, even when we are straightforward and on point. So I worry about what discussions leave a mediation if we're not crystal clear on.
Or even during the mediation, Lee J, they're calling each other, they're texting each other. The attorneys, sometimes opposing counsel, have relationships, and they're going, I have one in particular that I work with. I really don't like working with him. He just back channels me the whole day.
Yep.
And I mean, they'll tell me, oh, I was just talking to so-and-so and da-da-da-da. And it's like, well, what am I here for? This is really throwing a monkey wrench into everything.
I hate
I hate to interrupt for
Sure,
one
sure,
moment.
sure.
Great conversations. We're going to need to start wrapping up this very informative discussion so we can get into the next sessions. Thank you so much. Thank you, Lee J, for your input, and Steve and Wendy for a great conversation. So much to think about.
Thank you, Jennifer. And
Thank you.
I guess last thing I will say is, with all that said, the less we need to do so, the better. If it could happen organically, that's, I think, the magic, if I may coin the theme.
The great
Exactly.
workshop
I
on how to
agree.
do it well.
Okay.
All righty. Thank you, everybody.
For joining us. We have KMC and MC3 coming right up. They should be starting in about 2 minutes. So please go ahead and join them and learn more about our sister organizations.
Thank you, everybody.
Later.
Take care. Be well.